Bam. Going live. Oh yeah, we got to keep our voices down today because we are in the courtroom. Court is in session. Okay, sorry, I got a little carried away. I always wanted to say that when I was in court, but I was chained and shackled and they kept telling me to shut up. Welcome to Pro Se Legal School. I provide the tools, you guys do the work. I'm Coach Neighbors, and in tonight's live stream, we're going to talk about some stuff. So we're going to get started. Now I want you guys to type in the window there when you think the non-judicial process begins, and what begins that process. So I'd like to know who knows what on that. That's kind of what we're talking about. There's a lot of confusion. We're about to get that. Straightened out today. So we're going to talk about the non-judicial process, when it begins. Is there a court case? What kind of gangster stuff you can do to jam up their process before they get their ducks lined up in a row? And that gangster thing Brooke came up with. That was what she called the tactics that her coach was telling her to do. I loved it. So we might just use that because I think that's appropriate. And basically, we're just doing the same shit they're doing to them. Same shit to them they were doing to us. You. They're doing the gangster stuff too. But the problem is they gangster is not legal. So there you go with that. And so what we're going to talk about today, one of the things we're going to talk about together, Gantsa Tactics that we use to beat them down on the phone and stuff. Knowing the right words. Knowing the right words to say makes all the difference, especially if you've been in there doing a bunch of silly stuff and they have no respect for you. There are a couple of people that are kind of in that situation. So we're going to talk about some things that Brooke's been doing and a couple other people have been doing to beat them down on the phone and otherwise. And I'm also, last but not least, I'm going to explain to you guys, or maybe I shouldn't have to explain to you guys, but I'm going to anyway, why I no longer offer the non-judicial or the judicial foreclosure defense lawsuit package that I used to have on the website. They're trash. We threw them out. We no longer use them. And when we're done with today's stream, I'm hoping that you understand why we don't use them. And once you understand why we don't use them, you understand that why I don't need to hear about your special circumstances or about your situation or whatever. Did you sign the stinking mortgage lien? Yes. Did they deliver it to you like the law says they're supposed to? No. They registered in the office and we're going to talk about that too. And I think last, if I get to this, I want to explain to everyone why I generally do not coach folks to continue what they were doing before they found my service or my business or whatever. And I'm going to tell you why I don't generally do that. And one of the reasons why is that it usually ends up with a grumpy coach and a grumpy fighter, because when I'm coaching you to continue doing what you were doing, which I'm not that good at, I'm good at smashing their stuff, but I don't have everything worked out on that because that's not what I do. So I'm probably not going to do that anymore because it just creates a lot of drama and chaos. It's better to crush the state court process and then by adding the players and doing the things that we said in updated instructional videos, all 4 or 5 of them, and then get your stuff filed in federal court. That's what our program has outlined that we should be doing based off of the real-time feedback that come in from from a lot of people in the private coaching group and people not in the group and stuff. So that's how we do that. So I'm just going to throw that on the table right now, and that's why I don't. And now the other reason why I don't help you continue what you were doing is because it was defective. No offense to anyone, but if it wasn't defective, you wouldn't need me. You wouldn't need my service. You wouldn't have found me out, sought me out, or whatever. So just keeping it real, it's defective. Now, if you connect defective stuff with fire, they're not going to talk about the fire. They only want to talk about shit. Though I'm sorry, they only want to talk about. Okay, so here's the thing. It didn't take me a long time to figure out their program is structured for arguing. And when the arguing's done, what happens? y'all know what happened there, buddy. Judge gets to help them. So the non-conventional program is structured where there's no arguing. And there's no arguing in that program. We'll talk about that. So let's just get started right here. Now, you guys come in here from Facebook. Please go to this link and give StreamYard permission to use your Facebook username. Or if you comment, you're just going to show as Facebook user. So that would be cool if you could do that. And I'm just going to leave that scroll there for a minute. Welcome, John. First one up in front of the line. I love it. Yeah, John, we're not here to talk about what you did. We're here to talk about what I got to talk about. Okay, so we're not going to talk about what you did, and neither are we going to talk about what you did on it. You guys know how this works. Okay, we're going to talk about what I want to talk about, and then if I have questions at the end, you guys can ask me questions. The Facebook page for our business is where you can go and post all of these things that you want to talk about your case and about what's going on. And I'll post a link to that group here. And all you got to do is just like the page. And it's not the private group. The private group is full of a bunch of people that are been doing this for a minute. So new people have to communicate with me in Messenger until I feel like you are on board and understand what we're doing here. Otherwise, you're going to get lost in the group. And so I have a lot of people that watch old videos and think that they're automatically input in the group. Well, our business has changed a whole bunch since those videos that were put out 2 years ago. Thank you. Welcome to the show tonight, everybody. Now, I'm going to just move through what we got to talk about because we got a lot on the table here. And like I said, I'm not here to talk about your individual things. Those are things that you talk about in the group. People here don't really care about your individual things. That's not why they're here. I'm thinking they're here to talk about what I said we're going to be talking about. So that's what we're going to move forward with. Now, you guys, when does the non-judicial foreclosure process start? Non-judicial foreclosure process. Yeah, John, when does it start and what do they use? What do you get to let you know that you're in the beginning of that process? So anybody got an answer here for my question? When does that non-judicial process start? Well, I'm going to help you guys. I actually have when it starts, when educated people says it starts. Oh, and then I have when I think it started. So And so that's going to be interesting to see how that works out. So most educated people would probably say that the non-judicial foreclosure process starts when they mail you the notice of default letter or the acceleration letter, the letter to cure, the letter saying you're behind and you owe a bunch of money. That's when most educated people will tell you that the non-judicial process starts. Now, people who are not educated will tell you there's no case. So even though they sent you the letter and they tell you they're going to sell your house in 30 days, those people, they think they have time because when they go down to the courthouse, those fools tell them there's no case. Yeah, John, that's what educated people would say. And so I have a different idea about that. And now that I said that's what educated people would say, then I got to figure out where I'm at on that. So I'm just going to go out on the limb and say that I'm crazy because that's what the government said. They said I was mentally ill. And so here we are teaching you how to punch these people in the face from your living room or the bathroom or or the damn courtroom. Okay, from some room, we're getting it done. So yeah, so okay, the notice of default is a good answer to that, but in my opinion, the non-judicial foreclosure process starts at the signing table when your ass sits down to sign the stinking mortgage lien. That's when it starts, in my opinion. And I'll tell you why I have that opinion. I'll tell you exactly why. And the reason I have that opinion is because think about it. They're going to tell you there's no case. There's no case. You can't do that. Go sit down until we get in the eviction process. There'll be a case number in the eviction process. Yeah, but you just missed the whole. Oh, okay. So step back, like quite a damn ways, and look at this from another perspective. In my mind, and my mind's the one who put this paperwork together that y'all using to kick their ass. So even though they said that I'm mentally ill, I was, and I got well when I wouldn't take their deal and lie on my wife. Oh, after 33 months of being harassed. In my mind, the non-judicial foreclosure process starts the day you set your ass down and sign stinking papers at the Now, why? How can you? Well, think about it. How can they sell your property on the courthouse steps? There you go. I got it, JR. I got it. Okay, so how can they sell your house on the courthouse steps in 30 days if they don't have a case for you? Oh yeah, they have a case for your ass. It's in their administrative court, and they don't want to tell you about it. And in some places, when they do judicial foreclosure, like they did here in the state of Kansas, in my sister's case, they have there's a barcode on the bottom of that petition that they're serving. And in my opinion, that barcode represents the administrative file that they have on the other side that they don't want to tell you about, and that's the file that they're using to do all the stuff. So that's right. So the whole process was set up to do exactly what it's doing. So in my mind, the non-judicial process started at the gate. And so did the judicial foreclosure process, because everything is lined up to do what it's doing. Okay, you're still confused? Let me help you with that. How many of you people are in foreclosure and your house was posted on Zillow before you even knew your shit was in foreclosure? Or let me make it easier. How many people are in foreclosure and you got your lawsuit filed, you're fighting that shit, but they're still coming to your house, putting shit on your door and trying to get you to take the cash or keys and get the hell out of their way? Uh-huh. Oh, it don't take a rocket scientist to figure out they already have a program for this. This whole thing is structured by the same bar members that are taking your property. And that's why the conventional program is not going to help you. That's why arguing their lies is not going to help you. That's why wanting to talk to me about your unique case is not going to help you. And I have people get mad and hang up on me, which I'm thinking those aren't the people that done the homework. Because if they've done the homework, they understand. The reason I don't tell you what to do is because if you don't understand and you don't know the right words, it's not going to help you. And I don't want you to spend your money on my stuff if you're not going to do whatever it takes. So that's kind of pretty much where we end up at. Now, how do they come up with this alleged right to sell your house? Well, in non-judicial foreclosure, they use a clause in the deed of trust that allows them to sell your property. If you are in default, it allows them to sell your property without a court process. And that's what they use. Now, generally, to do shit like that, they'd have to have you initial that or whatever. Yeah. How many of you knew that in your mortgage contract that you signed, you agreed to pay all of the attorney's foreclosure fees for the foreclosure, the court fees, and you agreed to do arbitration or mediation, one of those two words. You agreed to do all of that. I'm sure that your realtor pointed all of that stuff out to you. I'm sure you took the time to read all like 35 pages. No, I didn't take time to read that shit either. I'm just saying until after the fact, and now we've learned a lot more. So that clause in the deed of trust is what they use to give themselves authority to do what they're doing. Now, the fraud started at the gate when the conspirators failed to deliver your property deed as mandated by the law. They failed to deliver your deed. They registered in their office. They call that their constructive delivery. Register your deed in their office. Oh, there's no law that says your deed needs to be registered in their office. Wow, you should be able to just call them up and tell you to take that shit out and say, oh, and but that's not the way it goes. Okay. That's not the way it goes. The fraud started at the gate when the conspirators failed to deliver your property deed as mandated by the property transfer statutes of your state, and they registered in their office. And that registration in their office allowed the first illegal lien to be put on your property. And I'm just going to throw it down and keep it simple, okay? The first illegal lien was a mortgage lien. Think about it. Think about it like this. If there were several people who owned property, before anybody could take out, all the owners have to be present to sign, right? So the fact that they accepted the signature from your happy ass on their paperwork proves that you own that shit already, and I smell stink. Can I get an amen? Okay, so this is a serious flaw in their procedures, and it allowed the first illegal lien to be put on your property. Now, the question is this, and I can't tell you this because the attorney got one of my Facebook ads shut down because they said I was scamming people and stuff. I was doing. I was scamming okay, so they said I was scamming people. So, okay, so here's the question. And this is a question that I asked that fool and why they got mad and got my shit yanked, but I didn't care because it wasn't helping me anyway. But here's the question. The question is, if your deed was not registered in their office, would the lender be able to verify that there was a mortgage lien against your damn property? I'm just going to let that sit there for a second. You're welcome. If your deed was not registered in their office, would they be able to verify that there was a mortgage lien against your property? Oh, yeah, they need your property information to fill out the damn lien. Oh, yeah, people tell me, oh, no, I put my lien in there so I can make sure nobody probably, no, that's such bullshit. That is total bullshit. I'm just saying it. It's bullshit. It is. Total bullshit. I'm just going to tell you how I know. I have people in Texas that were in foreclosure, and they had all the documentation to show that the lien had been paid off, the lien released, the lien, everything. So we went through the paperwork. And no, I don't do that now. So easy. This is back in the day. And what we found was that they go down to the county recorder's office. They fill out a fake assignment against your property. And they file it against your property. They know that 90-something% of us, of you, can't afford an attorney. And they know that those of you who can't afford an attorney for foreclosure is going to get thrown under the bus in the end, because the system is structured. That attorney that you hire is going to automatically get a cut of your property that they steal from you in the end, in addition to what they stole out of your bank account for the fake help. And that's why attorneys ain't going to help you. That is exactly why attorneys are not going to help you with this problem. Now, if your deed was not registered in the office, would they be able to even prove that there was a lien? That's keeping it real. Now, the goal of all of my stuff is to get your deed out of their office, not to $5 million, because there was never any money. The goal is to get your deed out of their office, and there's one other document that's in their office that you need to get control of. So now you understand they skate around your due process with their illegal procedures to get you lined up in their administrative court. Oh, wait, but there's no court case. So relax. Go home and throw your shit in the yard. There's no court case. That's what they tell you. Due process means that the corporation's procedures are supposed to be fair. And actually, the Administrative Procedures Act of 1946 is a federal law that's still to this day enacted, and it mandates that these corporations are supposed to have their policies and procedures in line with the Constitution. And they don't. And yeah, we mentioned that in our paperwork. Oh, that's their conventional system. Their conventional system was structured by them for you. And I think if I structured a system for your ass to follow while I'm stealing your stuff, I'm going to make sure that you're not kicking my butt at the end of the road. So that's that's kind of what how I would do that. So now you can see why we no longer argue what they did to us. We don't argue what they did. We don't argue what they did. Now we attack the why. Why they were able to do what they did. if you don't get the why, you're gonna keep getting punched in in your eye. You have to attack the why. Why were they able to get the eviction process, or why were they able to get the sale? All of those whys, in my mind, based off of the real-time feedback that I got from all of the people that helped me put this program together, tells me the why is their procedures. Their day-to-day procedures that they use that violate your due process. Now, how do these? Well, we can say they're not fair, but we can just take it a step further. They violate your due process because they freaking cheated and violated you all along the way. Revised codes and statutes are not valid laws. They don't have enacting clauses, they don't have titles, and they don't have bodies. Those are three things that the Constitution and federal law. So they violated you by making you believe that revised codes and statutes are laws that you have to follow. And most people are not very smart, and they don't look up what a statute is. And if they did, they'd find out that it's not a law. It's a policy put out by the corporation. So, yeah. And so before we get to stopping the eviction process, that's what we're going to talk about next. I just want to cover that the power that you are learning from the facts in these YouTube videos, in the Pro Se legal training videos on my YouTube channel, the power that you're learning from those videos is only limited by your imagination or your fear. It's only limited by your imagination or your fear. Now, I mentioned earlier, we do some crazy stuff. Brooke called it gangsta. Yeah. And so so let's just go over that right now. A couple of things, some of the things that you can do yourself to enjoy things and punch them in the face a few times. So one of the things that we do now, the demand for sanctions is only in the premium packages. So demand for sanctions for 3.5 million. There are two of them in the prosecutor eliminator package, and there are two of them in the mortgage fraud package, and those two will also be in the online course package for real estate deed fraud when I get that website finished up. Now, the demand for sanctions, you're filing against the attorney or the prosecutor, and you're demanding sanctions 3.5. You have two. The first one, you're demanding sanctions because the statutes and codes are not valid laws. And part of demanding sanctions is because the attorney didn't do a reasonable pre-filing investigation under Rule 11. And had they did a reasonable pre-filing investigation, they would have figured out that the statutes and codes are not valid laws, and they wouldn't have got in your face. That's it, like in a short nutshell. Okay, but the bigger, harder shell is that this is my slick-ass way of challenging the court's jurisdiction by like a mini lawsuit. It's kind of like a counterclaim that you file against, and you file this in their case without having to pay filing fees. And this is one of the ways that we crush the state court process or the federal court process. It don't matter what court it's in. This is one of the ways we crush the state court process to be able to get the stuff filed in federal court or whatever without worrying about the state court moving you up onto an eviction list or whatever. So, yeah. And this is pretty powerful because the attorneys, they can't state jurisdiction. And the statutes and codes are, wait. The judge is not going to want to have anything to do with this. The judge cannot rule on my stuff one way or the other without committing political suicide, pretty much. And thank you, Jack Butler, for that. Because that was a very clear way to put it. If they rule against you, they pretty much figured out you're going to sue them. because you're suing all the state court judge and the state bar association and all the other players who signed on to take your property. So yeah, they figure out that your legal team is not bar member smart people. I can use some other words there. Yeah, there. So they can't control you. Now, what we do is we serve a copy of the demand for sanctions, and you can serve a copy of your notice of claim or your lawsuit or whatever. We serve a copy of it on the players. And what Brooke did is she served the judge, and she wrote judge's chamber copy on the top, and she served the judge a copy of the demand for sanctions that she filed against the attorney. Now, you only add the attorney to this one. And then she also served the clerk. So the clerk got a copy. And yeah, I know people are saying, well, wait, there's what case number? You don't need no damn case number. Look, you only need a case number if you are planning on going before the judge and have the judge rule on your stuff and all of that. We're not doing any of that. And so you don't need a case number. What you need to do is you need to get your facts in their face. Okay, that's what you need to do. You need to get your facts in their face. At the end of the day, if the judge denies your demand for sanctions, then the judge is going to be on the hook for helping out his buddies. Yeah. And they know that. They figure that out by reading the paperwork. Mm-hmm. You know, when you hand them the stuff that you get from me and they take it back in the back room and they're back there for 20 minutes. And then they come back with 2 people or maybe 3 people. And then they try to tell you that you can't file that because this or that. If you've done your homework, you'll know not to take your shit back. Okay. When they start giving you a bunch of crap, you'll know just turn and walk off and tell them, look, I'm on camera filing my stuff. You guys can do whatever you want with it. Please mail me a copy or send me a picture of the trash can. Whatever you guys decide at the end of the day, because it ain't my call and I don't care. It's in your hand. I give it to you. As far as I'm concerned, it's filed. Now, the goal here is to prevent them from going through with the court process. That's one of the attorneys complained about the sanction document, the demand for sanctions. One of the attorneys that was giving my sister a hard time. I mean, my friend. I can't talk about my sister's case, but my friend. He was complaining that the sanctions is something you can't use the sanctions before trial. That's something you file after trial. Well, wait a minute. If y'all screwing up, why would I want to wait till after trial to address it? Maybe that's how y'all do it in a conventional program. But that's not how we do it over here when we ain't trying to be going through all of that. Yeah, they didn't like that one bit. So, yeah, and you don't have to, what? Oh, yeah, those rules that they're saying was this or that, that's not anything that we have to follow. And I certainly don't allow their limitations to get in my way. So what you guys should be doing is calling the attorneys and asking them for facts outlined in the lawsuit, about if you got the mortgage fraud package, then you want to talk to them about the 6 missing things. That first thing is that that's missing off of the contract that they filed against your property is that you agreed with the lender that the lender was going to do a deal according to the Gantsa County principles. You agreed to that in the contract. You have your copy. Just lie out your ass, just like that. Just lie right. I mean, it's like, well, come on now. Okay, at the end of the day, if you act like that really happened, what do you think? What do you think they're going to do? Yeah. The first time you call, no, you may get through to the attorney, but after that, oh, hell no. No, they're going to send you to the gatekeeper's going to send your butt to the voicemail. So, which is cool because then you can just read your stuff. Yep. Just hold it up there and read your script into the phone and talk trash. Uh-huh. I'm serious. Talk trash. Oh, this is the part where you get to have fun. You want them to know that you're going to be an asshole. And you want them to know that your legal team hates their ass. Yeah, I harass them daily, almost, emailing. And yeah, actually, I sent the emails to my sister so she could send them over to her, man. Yeah. We did stuff like we added the attorney's assets and the attorney's property to my sister's civil claim. Yeah, we did. And they got really mad. I mean, they got really stinking mad. But you know what? That's what. If they're not mad, you're getting your ass kicked. So, So once we did that, we hooked up who was signers on the property, and his wife was a signer on the property. So we had to add her to the counterclaim, and then we served her a copy of the counterclaim, and that's why they were really mad. And they don't. We also had the Kansas Bar Association. So, and we mentioned in the document that we're going to have a little. They're probably going to have federal attorneys help them because state bar association attorneys would have a conflict of interest. Oh yeah, man, you guys can have so much fun doing this. Now, we also serve the sheriff department and the city's risk department. And we also serve the auction sale company, the documents. Now, before we served the documents, what we did was we placed them in the public record. And by placing the documents in the public record, it's supposed to give you, it's in comments or something. I haven't done all the rest of that, but it's pretty badass. And so that's what we did. And it removes the free pass for them to manipulate your paperwork. Because when you have that stamping on there that has been placed in the public record, then it's a little bit of a problem for them to do what they've been doing or would like to do. Now, this process that we're talking about allows you to add the prosecutor or the attorney, the state, the judge, all of them, depending on if you're state or federal, if it's criminal or property situation, to their own case without filing fees. Now, keep in mind, not every package has the demand for sanctions in it. So I don't want you calling me telling me that you didn't get that in your package, because if you didn't spend the package is half price right now, $1,500, and if you didn't spend $1,500, then you didn't get that package. Now the mortgage fraud package price is going to change for it sometime next month when I get finished with promotions and the pages and everything, because that package is now being offered for people to use. It has offer to pay letter in it, so now people can use it to challenge the mortgage fraud before they're in default. And if they don't follow up with the offer to pay letter and do the right thing, you serve them an offer to pay letter, and now you're letting them know your legal team is expecting them to call them with a date that they can show with the original instrument of indebtedness, which is what the law states they're supposed to have if they call in the loan. Now, most people don't have the statute for that, but we do, and it's in the offer to pay letter. And you serve that on them too, just like you did the other document, so they can't say they didn't get it. Now, the beautiful part about that is when you've offered to pay, they can't foreclose on you. This is a new, really cool ass way. It's like show me the note, but you ain't saying show me the note. You're just telling them to show you what the law says they're supposed to have if they want to call in the loan. Now, if they can't do that, then they, if they want to file for foreclosure, then you can, hey, there's no moot have it dismissed. There's no controversy because I offered to pay. Here's a letter that was served to them, and they could not set up a time to, oh, wait, excuse me, Judge. My offer to pay is still open. They like to sit their happy ass down at the table right over there. Uh-huh. And so you see how powerful that package is now. Very powerful. Now, you're saying there's mortgage fraud. There's 6 things, and these 6 things outline how the thing went down. Now, they want to be stupid. Then you got the mortgage fraud lawsuit to file to clearly address all of those things. Plus, in that lawsuit, you're also addressing the state's day-to-day procedures that violate your due process. Plus, you're also addressing the lack of jurisdiction. Plus, I could go on for a minute on that. That mortgage fraud lawsuit package is the bomb. Now, what we've been talking about is why I no longer offer the non-judicial or the judicial foreclosure defense packages. Okay? We don't argue that stuff. We don't talk about those things. We want to talk about the procedures that they use to line your ass up where you are now. Like the fact that they registered your deed in their office, and there's no law that says you have to do that. That's just, one or two of the top. No. And that's why I don't need to know all about your special situation. People get pissed when I don't have time to listen to them vent and be emotional when we don't use any of that stuff. As a matter of fact, those things don't help you in my program. Being emotional and grumpy and all of that doesn't help you because it interferes with your ability to make decisions. We no longer argue their lies. We argue the whys. Okay, I made that up earlier. Okay, but we don't argue their lies. We argue the why they were able to lie. Why the lies? We can spend a minute on that, but we're going to move forward. Okay, so now to stop the sale, the eviction process, one must attack the reason why the players were allowed to sell or to do the eviction. You're not going to stop the eviction process arguing the eviction in court. You're not going to stop the sale. You're not going to stop anything arguing their lies because that's what they want you to do in their conventional system. While you're arguing, they're throwing your shit in the yard. So, or they're handcuffing your ass. We do not argue. Okay, so to stop the sale or the eviction process, you must sue them for the reason why they're doing the sale. And that's why we no longer have that eviction package. I had a little eviction package that I put together to help people who who were going to invest in the package, weren't ready or whatever, but people thought that's all they needed was a $75 thing, and bam. And no, stopping the eviction process is a pain in the butt. And the only way that we've been able to do it consistently with people that are rookies, okay, let me say people who are not assholes, okay, because sometimes you got to be a real asshole when you go in there and talk to these people. But the only way we're able to get that done is by filing a state lawsuit in state court against the eviction players, the state, the judge, all of the players that you generally add. You just add the eviction players to it. We file that in the state court, not the municipal court, because that court don't have jurisdiction to be doing none of the shit they're doing. And then once you get that filed in state court, after you add the state, the judge, and the players or whatever, then you have to get your federal lawsuit filed. Now, in my perfect world, the way this should work is Once you get everybody, once you serve the players on a state level, they're not going to be able to answer. Judge is not going to be able to answer to my stuff. I'm just telling you. There's no way in hell. They're going to have to recuse himself. Okay. And with the judge recused, even if the attorneys want to put some bull crap on the table, it ain't going to mean crap without a judge. Without a motor on their boat, they got crap. And that's why we take the judge out. So now you've got the state, the judge, and then you file in federal court, serve all of those parties. Once the parties are served, then you demand that the federal court judge order those parties to settlement table, settlement hearings. Yep. And the reason that you're ordering them to, or you're demanding they order them fools to the settlement table is because they could not respond to the state court beatdown. They have no standing to respond to anything that you filed in federal court. Bam! Oh, there's your nice, nifty little plan to get your whole thing through all the court system without showing up for a hearing. Yep. They got a nice, nifty little plan like that too, but I think ours is kicking their butt real bad. Well, I know it is. So now we figured out that we have to attack the procedures. And this keeps taking me back. And it finally hit me in the face like a left hook. We need to address the procedures that they're using. Now, almost everything that I have is 42 USC for traffic, 42 USC for a foreclosure offense, 42 USC for credit card lawsuit. 42 USC. People, that's what we're doing now. We're not arguing their lies. We're going after them for the procedures that they use to line y'all ass up where you are right now. Now, I hope this shines some light on why I don't argue their lies. And when you do your homework, you'll find out that the 2 foreclosure offensive packages can be used for judicial, non-judicial, tax. It don't matter. It don't matter. If you're in a tax lien situation and you got the foreclosure package, you got the either one of them, stick it in their face. Yep, dude, use that package to hold the tax people accountable for the mortgage fraud. Yeah, and so what about the home? People that run the home mortgage and people that run, all of those people are violating you. We don't argue their lies. The 2 packages now address either judicial or non-judicial. It doesn't matter. What matters is they violate you at the gate and committed mortgage fraud. And that's what both packages address. One addresses mortgage fraud, one addresses the due process violation. It's not about all of those things that everybody want to talk about. It's not about none of that stuff. We don't go into court and my stuff arguing. And if you spend your time reading the paperwork, you understand. If you can't understand this, it's going to be difficult for you to reach the goal in my program. Because the goal of my program is not to get the judge to give you shit. The goal of my program is to make them fools tap out and go sit their happy asses down. That's the goal of my program. So you guys have to keep that in mind. Now, if you're facing this problem, you don't have a freaking case number, you got plenty of stuff you can do. Get your package and get your butt to work. You got plenty of stuff to do. If you're in that situation, you have an opportunity to convince them that there's not going to be a lot of value in trying to take your shit. If you're in that position, you have an opportunity to do that. Most people in that position are so worried about the house got sold. We're so worried about, okay. The house can sell all day long. None of that matters. I tell people stopping the sale of your house is not the most important thing. The most important thing is having a game plan that's going to block the eviction process, because you can stop the sale all day. We do all day long. And when you do that, they're going to call a timeout and they're going to throw your shit in a basket over there underneath the table and leave it sit. They're going to move your ass up on the eviction list and try to get the sheriff out of your house as quick as possible. That's what they're going to do. And it's not going to do a whole lot of good filing anything at the last minute, because they're not going to. We've been through all of that with people. And that's why we have the program set up the way we have it set up. And I have people that come in and want to change the program. They want to tell me about what they were doing and how, I don't want to hear that right now. We need to stay focused on what we're doing here that's working. So I hope that shed some light on this situation, you guys, with the non-judicial. So I got people telling me that I don't have a case, so I have plenty of time. Oh. Okay, hey guys, that's all I got for tonight. Anybody have any questions that they want to throw on the table? I'll spend a couple of minutes asking your questions if you have them. Get over to the right screen. Yeah. There you go, man. Oh, that's what I'm talking about. At closing when the note's stolen. Perfect. That is perfect. Welcome, Afro Wealth Reviews. Welcome to the show. You're new here. I love it when people come in that have an idea of what's really going down. So, and that's perfect. At closing when the note was stolen. That's oh, those are like perfect words. That's put like you have some serious idea. Thank you, young man. At closing when the note's stolen. So, Afro, are you here to learn, or are you going through something? Send me an email. I like that answer you got. That's number one answer. Number one answer gonna get something in the house. Thank you guys for the value of sharing your time. I see you guys in the next live stream. Stay in the ring. Stay in the ring. And keep punching.